So I'm Joe Nohavicka. I'm Tasso's partner. I've been doing this for a while now, 26 years in law, but this is my second career. I'm actually 61, and I've been in business, as Tasso told you before. Let me see if I can share some of my experiences with you. And I'm not saying this because I think I'm smarter than anybody. I'm telling you, I've just been down a road that you all are going down, and I have seen the pothole, I've seen the log in the middle of the road, and I've seen the edge. And I'm sharing with you right now because I tripped in the pothole and over the log and fell over the edge. And so I'm here, I survived, and maybe I can help you with some things. So you followed Tasso's advice and you followed Natalie's advice, what they've been talking to. So you have your business planned, it's solid. You have your office picked out, your furniture's picked out, business is good. You made all the right moves. Now you got to keep making the right moves. Because business is good, you want to make it better. And so the first thing that pops into your head are employees. Maybe you started out with them, but usually it's you get things solidified first, and then you start onboarding your employees. And let me just tell you before I even get into the employer-employee relationship, there are other options out there. You don't have to get an employee right away. They do have these staffing services that are a little more expensive than having an employee, but it saves you a lot of problems because they cover things that you wouldn't have to worry about too much normally. So it's a good way to start off, and something to keep in the back of your mind that business startups do use staffing services initially. It's not a bad thing. So interestingly, the topic that Tasso has given to me is working with others, which I find kind of ironic. But I'm gonna discuss this. And it's not just working with others in the workplace, because we're really working with most of our employees remotely. But basically the same rules apply, and you have to be even more careful when you're dealing with employees and the employees are dealing with each other. There was this great 2014 article, Computers and Human Behavior, and they talked about how people are emboldened when they're online and everything. And so they write things or communicate things that they wouldn't normally do if they were face to face. So as employers, you have to be aware of that. And you have to, when you're onboarding your employees and when you're talking during staff meetings, you have to remind them that there are protocols and there's behavior that's not acceptable, that wouldn't be acceptable if you were face to face. And that should be the touchstone for everything that they do. Unfortunately, I cannot see anybody out there. And usually when we have these live, I get to see these creative and courageous people, and I get this vibe from them, how excited they are to be going into business. And it's a wonderful thing. It's so exhilarating. I almost envy you people who are going into business on your own right now. It's a very exciting time. And even though we have these problems that are existing, they're going to pass. And you know what? Your business is going to continue on. It's not a bad time to be starting a new business either for many of you. So one of the things about the remote, one of the other things I wanted to talk about was, when you set up for remote conferences with your staff and everything, you have to respect their emotions about things. If they choose to not have their video on, you can't force them to put their video on. They may not be comfortable with having their boss inside their house. That's okay. That's, once you start invalidating emotions with your rationale, you're putting a wedge between you and somebody who's taking care of your business on a day-to-day basis. So you have to be very aware of that, and not invalidate emotions of anybody in your staff. And by the way, it's not such a bad rule to keep in general. Even when you're outside, invalidating emotions is the number one way to curry resentment. And resentment in a company can be very bad. We'll talk a little bit more about that later. So we're going to talk first about employee handbooks. As I said, you made all the right moves. Don't start skimping now. If you're going to have employees, you got to have written policies, and it should be in the form of an employee handbook. Going onto Google, you're going to get something, and that's something. That's a little helpful, but oftentimes it gets you into even more trouble than having nothing at all. And I'm going to tell you right now, there is absolutely no general silver bullet handbook that you're going to get from anybody as a one size fits all. Every company is different. Every company has different problems, issues, setups, and they should all be addressed. In the handbook, and this is a customized handbook, the first thing you want to address is the working expectations for both the employer and the employee. And this should be written, it should be articulated in your handbook in plain English. If you are reading this thing and you need a lawyer to interpret it for you, throw the book out and start again. Everything should be in plain English so that everyone understands, whether that's your employee, whether that's the administrative law judge, or whether it's the federal district court judge in the Southern District of New York that's going over while you're in the middle of litigation. And I'm telling you right now, your employee handbook as an employer will be your best friend. It will be your best friend as an employee as well, because it explains everything and you cannot deviate from the written word if it's clear to everybody. It's only if it's ambiguous, only if it's unclear that it becomes a problem and you need a lawyer for it. So you have your working expectations, you have your policies of how, for example, how to treat each other, whether it's remotely or in person. And we're going to get more into the sexual harassment policies a little bit later, but generally policies in the workplace. If you require in your job, in your business, for everyone to be dressed a certain way, then you should make that clear. So at least the employee has an opportunity to say, no, well, I'm not wearing that. I'm not, this is, I'm just not going to do this. All right, so they found out this is not someplace they want to be. They know at the outset. It's not a surprise to them, and then, people come in and they dress a certain way that's against your personal policy, and they're there for months. And then you say, you know what, I don't like this guy. And you call them in and you say, I don't like what you're wearing. It doesn't, you don't meet our profile. You're out, I mean, that's not fair. And, if you get it brought before that issue up before a judge or administrative law judge or arbitrator, they're going to agree with the employee. Next thing you want to talk about clearly is discipline. Like, what will happen? The employee has to be on notice. If they come in late 5 times during a certain working period, they're going to get a warning. After the first warning, they're going to get terminated, so that they can't go in when they're fired after missing 10 days that they didn't have notice of what the expectations were, what their obligations were. So it's got to be made very clear as to what the discipline is, what it means. All right, it's got to be spelled out. It can't say, you're going to be disciplined for cause. That's not enough. That doesn't mean anything. You will be if you strike another employee. I know this is very specific, but if you strike another employee, you're automatically terminated. Okay, clear. So somebody goes in and they're pushing them around and they do something like that, they're going to get fired. They knew that they were going to get fired when they did it. They did it anyway, and that's the end of it. And then finally, your employee handbook has to discuss protections from claims such as harassment, like I said, and for wrongful terminations. And that is just very clearly spelling out what they're required to do, what they're required not to do. All right, and this way it's not a guessing game. So as I said, the employee handbook becomes your best friend especially if you're an employer, though, because you're usually the one defending a termination. And one of the problems that comes up is it's someone whose first language is not English. It's another one. All right, they were fine. They spoke English during the whole time that they worked with you. You didn't need an interpreter. They understood. They did their job fine. Now, all of a sudden, they're claiming they don't speak English well. And they come to you at the Unemployment Insurance Board for a hearing, and they have an interpreter. You're like, what is this? I'm going to tell you one thing. First of all, people whose second language is English, their command of that second language, that English as a second language, diminishes in proportion to the amount of stress that they're encountering. And court depositions, hearings are very stressful situations, and they forget everything. That's just the psychology of it. That's what happens. They're not trying to trick anybody. This is just a reality of how it works. Some are better than others, but if they're requesting an interpreter, that's the explanation. It's not because they're trying to trick you or they're trying to curry sympathy from the tribunal. So how do you resolve this? You had no clue as to whether or not they understood the employee handbook. Well, what you do is you insert a page in their first language that says that I have been given an opportunity to have an interpreter interpret everything, translate everything in this handbook. I understand that and I waive that in their language and in English language. So you can present both of them to the tribunal. All right. And that's how you defend yourself against that. That's one thing. And it's a really, really important thing to have. All right. So there's your employment handbook in a nutshell. And as I said, there's no one size fits all. You have to come into us or you come into your lawyer and you explain exactly what it is, how your company is set up, how you communicate with each other, and spell out everything from benefits to discipline to behavior to and everything that's got to be there. It doesn't have to be a giant book, and make sure that it's in plain English. Okay, stay away from the legalese. It sounds really cool and stuff, but it's totally useless if no one understands it. Harassment policies. Our firm, we give seminars and we give instructions, counseling to managers who really don't understand the boundaries that are supposed to be in place. And I'm not smiling because I'm downplaying the importance of this. I'm smiling because of the stupidity of these people who are so educated in such high positions with such big power. They ask me and Tasso, well, this is an actual quote. We're very affectionate at our firm. I mean, and I'm not going to even go into how else he was explaining their behavior. But I mean, really, you're very, anything that comes after we're very affectionate at the firm is going to end up in a bad place. All right. It's like, come on, smarten up. You're affectionate. This is a workplace. They're being affectionate to you because they work for you, not because they think you're the greatest person in the world, you moron. Yeah, you get it. You see our frustration with this? They need sensitivity training, and you have to have strict policies in your organization, so that when you're onboarding a manager, or it doesn't matter, from the highest to the lowest position, they all have to understand that you take this very seriously. You set the tone. The owner of the company sets the tone about how they treat harassment and discrimination in the workplace. You set the tone. And if you're the guy who sets the tone, or you're the woman who sets the tone, you say, we're very affectionate here. I mean, where does it go from there? That you don't understand that the need for this boundary, where an affectionate workplace is just inappropriate on its face. All right. So your policies have to be very clear. And this is something, especially if you're in New York alone, that is very, very strict. And there are a lot of little things that you have to be careful of. And you have to show proof that you actually explain these things of what's appropriate and what's not appropriate. A lot of it is common sense, you would think, but it's not. Okay, so everything has to be spelled out for them. And the harassment policy should also be included in your employee handbook. And that brings us to harassment training. As I said, we train managers but new employees should be trained as quickly as possible. We just had a new case in a store where one of the employees thought it was appropriate to pick up one of the cashiers and say, "Oh, you're so late." I mean, does that seem sane to anybody? I mean, you imagine, somebody who you care about, somebody from your family getting picked up by some idiot, in a shop. I mean, really, they think that that's okay. And you know what? It's not all his fault. Okay. They just don't know any better. It's really the fault of the employer for not explaining and setting the boundaries, and maybe even setting the tone of that everybody is to be respected here. No, you can't just pick people up. You can't touch them, and it's just not acceptable. It's, sexual harassment is, it's a crime against people, but it's also a crime against industry. It excludes a whole group from having a peaceful workplace. Think of that. It's a crime against industry. So your harassment training which is required, by the way, now in New York. You have to have harassment training every year. And the person who's training, as we do, we give examples of what's appropriate, what's not appropriate. We give the picking up the employee example and make sure that everybody understands. For employers, the important thing is that you have to keep records of your training, who was there, who did it, how long it took, okay? Because you're going to get audited by the Department of Labor or the Equal Employment Opportunity Commission, and you're going to be required to pull those documents. And you should keep those documents for no less than 5 years after the termination of that employee, because as I said, you might get audited. As a matter of fact, I recommend, and Tasso recommends, 6 years of keeping them. All right. Tass, I'm sorry. Okay.
We also perform that training very often in other languages as well, which I think is something that's very important for a lot of you.
Yeah, absolutely, because then they have the same defense available in the that I gave as an example with the employment handbooks, the employer handbooks, employee handbooks, that they say, well, I just didn't understand it. I think it's very helpful to have that translated document saying, that acknowledgement saying that they were given an opportunity to have it translated and they decided that they understood okay. And this way, that's very strong proof. Let's talk about contracts, okay? It's a little less, antagonizing, I think. Because I even get upset by this, by seeing what people do to perfectly good businesses, perfectly good, and they have one person who doesn't understand discrimination and what it is, and thinks that they can be flip about, they have no understanding about microaggressions or offending people using subtext. Anyway, that's for training. Those are things that we take care of. Make sure the people that you onboard are inoculated against that, okay, and that they understand that it is unacceptable. Employment contracts. Your employment contracts, I'm going to be brief on this because it's a little dry, but your employment contracts should not be taken off Google. That's a sure way to end up in trouble. It's very cheap, but you made all these right moves. As I said before, you had your solid business plan, you have your lease, you spoke to Tasso, you spoke to Natalie. Now you're going to blow it on a contract, and you're going to go to Google and download and hopefully you're just going to hope that that's going to hold up in court. Bad move. Compensations, benefits, termination, everything should be spelled out in the contract. Okay? Same warning with the language if English is a second language. Okay? Just make sure they have it in there. And you're not going to be violating any laws by saying, like, here's the contract. Would you be more comfortable having it in another language? Would you understand it better? That's not discriminatory at all. All right? You can ask that. You're trying to accommodate them and make sure that they understand everything. All right. Non-disclosure agreements for you entrepreneurs out there that have more ideas, and now you're going to share them with other companies. All right, you must have a solid non-disclosure agreement that's in compliance and under the protection of New York state law, which is different from other states. I mean, generally, it's that you see some common things, but if you pull off a non-disclosure agreement off of Google and you look at one of ours here in New York State, you're going to see differences, important ones. Hopefully that won't be too late, okay? Non-competes for your employees. This is important too. You have people that are working for you, all right? And while you're paying them from 9 to 5, they are starting up with an outside partner, a company just like yours, using your models, your pricing models, like for example, we had one with the pesticide company, and they were taking their mixtures of chemicals and to save money and still get effect. These are all things that are protected. So they're out there and they're starting their own company while you're paying them. Two things. Number one, it's illegal to do that. There's a doctrine called the faithless servant doctrine, which means that you have a duty of loyalty while you're working with your employer. If you do something on the outside, like the model that I just gave to you, they can grab and they can force you to disgorge every penny that they paid you from the moment that you started with this faithless servant behavior. So you risk losing everything. All right? Anyway, this non-compete agreement lays it out clearly what the employee can't do. All right. This way they can't say, I didn't know. We wouldn't do anything to hurt, to hurt that company. They were good to us. And finally, independent contractor agreements. For those of you, it's kind of strange to have that here because we're assuming that you're getting employees too. But, just remember, the commercial law, in commercial law, actions speak louder than words. Okay? Plain, simple, non-legalese. Actions speak louder than words. It doesn't matter if you say that you are an independent contractor or that person is an independent contractor and they signed and they agreed and they notarized it and acknowledged it. It doesn't matter. It's how they behave, how they're treated in the workplace. That's what determines whether you're an independent contractor or not. Don't screw it up. Just getting down to the final points, as far as documenting everything. Business is taking off. You're getting new clients. You're getting more business. Don't start getting lazy with your documentation. You must document everything with respect to day-to-day activities, with respect to how you're protecting your intellectual property, how it's being used, how it's being put out there in the public. These are all very important things. Document everything. Okay? This alone is like a 3-day seminar, just this topic alone, and I can go on, but I'm going to stop right here. I hope it's been helpful. And if you have any questions, I will be available, as well as everybody else on the panel.